Welcome, everybody, and thank you for joining us for today's presentation. My name is Sal Gangemi, and I am a member of the Labor and Employment Group here at Merthyr Kalina. Today, I'll be talking to you about applying performance and conduct standards to employees with disabilities. First, I'm going to take a moment to go over a couple of housekeeping items. All callers are currently in listen-only mode. But if you do have questions during the presentation, you can write them in the question box or the questions box of your webinar toolbar, and we'll answer them at the end of the presentation. This webinar is being recorded. All of today's participants will receive an email following today's presentation with the PowerPoint slides, a link to the webinar recording, and an attendance certificate. Okay, so let's begin. Oh, I think we're having an issue. We're having the, okay, there we go. Sorry about that. Let's start over. Okay, so what are we going to be talking about today? We're going to be discussing the basic requirements under the ADA. The basic requirements really set up the framework for evaluating the issues that we're going to be discussing, okay? And then we'll talk about performance standards, conduct standards, and throughout we'll touch on some recommendations. I'm also going to give you some examples of scenarios of what sort of comes up in the workplace to help you basically consider some of these issues and these are real life examples also. So they aren't going to be too far-fetched or too out there. First, let's talk about the basic requirements. Under the ADA, okay, employers are prohibited from discriminating against a qualified individual with a disability. Now, although we're emphasizing or talking about the ADA, obviously you're aware that most states have anti-discrimination legislation in place. So, for example, Connecticut, New York, and Massachusetts all have statutes that prohibit disability discrimination, and they might, and they do rather, define disability a lot more broadly than the ADA does. But for our purposes, we're going to just assume that we're dealing with the ADA. The obligations for providing reasonable accommodations under the state statutes are generally the same. Okay, but the definitions are slightly different. So, what is a disability under the ADA? It's a physical or mental impairment that substantially limits a major life activity. Okay. It also includes a record of such an impairment or a record of having had such an impairment and being regarded as having such an impairment. What is a qualified individual, right? So the ADA only applies to qualified individuals with disabilities. So what do we mean when we say qualified individual? Essentially, it's basically someone who possesses the required skills, education, or experience in the position at issue, and most importantly, they have to be able to perform the essential functions of the job with or without a reasonable accommodation. So when we're talking about an employee with a disability, we're talking about someone who has an impairment that does provide some substantial limitations, but the employee can't be too disabled where they wouldn't be able to perform the essential functions of a position, of the position with or without a reasonable accommodation. Okay. Let's talk about reasonable accommodations, okay? Generally, employees are the ones to raise, or they're the ones who are obligated to raise a reasonable accommodation request. Ideally, okay, it's always best for the employee to make the initial request for a reasonable accommodation. Once it is requested, employers are obligated to do one of several things, all right? either grant the accommodation, okay, that's being requested, or engage in the interactive process to determine whether alternate accommodations exist if the requested accommodation is not practical or feasible. Some states, like, so for example, in New York City, not even New York State, in New York City, they refer to the interactive process as a cooperative dialogue. And the reason I bring that up is to sort of give you an understanding. It really means the same thing as interactive process, but to give you an understanding of how it's generally supposed to be a give and take process where both parties work together, both the employee and the employer work together to arrive at an accommodation that actually works, okay, that works for both sides. If it doesn't seem like there is an accommodation that would work, you have to be prepared to articulate that the requested accommodation or any alternative accommodation would pose an undue hardship to the company. There are very few accommodations that do pose undue hardships. So again, you're evaluating these situations on a case-by-case basis, and it's something to keep in mind. Now, although ideally we want it's best for the employee to raise the request for a reasonable accommodation, an employer may be required to initiate those discussions, okay, when the employer is aware of the disability and the possible need for an accommodation. So really, when you're dealing with obvious disabilities, it may be incumbent upon an employer to start that interactive process. Or if the employer is already aware, based on the employer's prior disclosure of a disability, it may be incumbent upon the employer, and we'll talk a little bit more about that further down in the webinar. It may be incumbent upon the employer to get the process started. Generally, and this is the position the EEOC takes, generally an employer's disability should have no bearing on performance or conduct standards, okay? But in the real world, things sometimes are a bit more gray, okay? We're not dealing with black and white situations. In most instances, performance or conduct standards or problems should be addressed the same as they are for employees without disabilities, okay? We treat everyone equally in terms of our application of performance or conduct standards, all right? Keep in mind that the purpose of providing an accommodation is to address disability-related performance or conduct issues to help the employee meet performance goals and or avoid misconduct or conduct problems. Reasonable accommodations are not intended to excuse or tolerate performance problems or conduct problems. You're not required to lower, okay, your performance and conduct expectations in connection with a reasonable accommodation, okay? So let's talk about some of the types of performance standards that the law recognizes that employers are entitled to impose. And some of these, and probably all of these, are obvious, but let's go over them. So, for example, an employer can impose specific training licenses or certification requirements, okay? An employer can also require that certain physical or mental abilities exist. So, for example, vision, hearing, or lifting requirements, including, for example, being able to exercise good judgment. These are things that an employer is entitled to impose standards on. Of course, meeting health or safety requirements, as well as demonstrating certain attributes. You know, it may be important that you require employees to be able to work with other people, or to work under strict deadlines or under pressure. The ADA is not intended to require you to remove these requirements. You know, so in addition, job-related requirements may also typically include specific tasks, job duties, or assignments, okay? And this is what we refer to as the essential and marginal functions of a position, okay? Remember, you're not required to eliminate essential functions when you're dealing with these performance issues. The law doesn't require that, but you may be required to remove marginal functions, functions that are less important. A job may contain requirements that ensure appropriate performance or job duties or related assignments. For example, you can require that employees, that overtime, working overtime, for example, is an essential function of the position, depending on the circumstances. Of course, it goes without saying when I say you can require overtime, obviously you're going to pay them overtime, an overtime premium, but that can be viewed as an essential function of the job, okay? And it's something you're not barred from requiring. Employers are also entitled to establish evaluation methods. You're not required to modify your evaluation methods, although you are required to provide accommodations to employees that will allow them to understand or follow the evaluation. For example, for an employee who is blind, you may be required to provide the evaluation in Braille so that the employee is able to understand and comprehend fully the evaluation. So you may be required to provide reasonable accommodations in connection with an evaluation method, or rather conveying the evaluation, but not necessarily the standards. An employee with a disability is required under the law to meet the same standards as other employees in the same position, okay? And when we talk about performance standards, okay, we're talking about quantitative standards and qualitative standards, all right? A reasonable accommodation is not reasonable if it requires the lowering of a production standard, but it may require an accommodation to meet that standard. So basically, you're not required to lower the production standard, but as a reasonable accommodation, you may be required to modify how the employee satisfies that standard. Okay, so you may have to require that, be required to allow them to take a different road to that same result. Okay, in certain instances, but in most cases, generally speaking, you're not going to be required to modify how they get there, all right? Essential functions are the most important job duties, and those are the ones that need to be accommodated. They're the critical elements that are necessary to be performed in order to achieve the job, all right? Marginal functions are sort of tangential. They're not as important. Maybe they're utilized in order to perform or reach a goal, but they're not necessary to the job and can be eliminated. In fact, in providing a reasonable accommodation, you may be required to eliminate marginal functions, okay? If an employee or job applicant can't meet a specific qualification standard because of a disability, it's incumbent upon the employer to demonstrate that the qualification standard is job-related and is consistent with business necessity. Okay, basically, what we're saying here is that the qualification standard needs to be a legitimate one. It can't just be an arbitrary or unnecessary one. It really does need to be job-related and consistent with business necessity. So under those circumstances, you really need to know what functions of a position are marginal and which are essential. And so, which is why we basically advise our clients that you should review your job descriptions on a periodic basis just to make sure that functions that are designated as essential are not really just marginal, okay? It's not enough, for example, that just because a particular function has been designated as essential, that it is in fact so. And you might have a position, you might have a function listed in a job description for years and years and years as being really an important function, when in fact over time, due to technology advances or other reasons, the function really isn't so essential. So it's important that your job descriptions reflect which are marginal and which are essential. So for example, how important are timetables and deadlines for a particular task? Now, in many instances, deadlines are absolutely important, but there may be interim deadlines that aren't necessarily as essential as one would think. Okay, and so where they're marginal, it should be clear that they're in fact marginal. Again, supervisors should evaluate job performance of an employee with a disability in the same way that they would evaluate any other employee's performance. You really should be providing accurate evaluations, okay, regardless of the person's disability. You should not make concessions or lower your expectations regarding an employee's performance simply because that employee has suffers or has a disability, okay? Because under those circumstances, if you're not accurate, the employee is never going to improve their performance, all right? And so, or request a reasonable accommodation. If they think they're doing a great job, why would they think that they need to make a change or otherwise request a reasonable accommodation? So accurate evaluations are absolutely critical. And the law really emphasizes, and the EEOC regulations require that you be accurate in your evaluations. So it's important. Here's a scenario. This is an important scenario. So let's say an employee discloses their disability in response to a lower performance rate. So this deals with a situation where the employee and the employer are meeting, and the employer has basically conveyed that performance isn't so great, okay? First, the supervisor should not focus on the disability once it's disclosed, okay? The performance rating reflects the employee's performance regardless of what role, if any, that the disability may have played, okay? Make it clear to the employee why they have earned the lower performance rating, okay? Or why the supervisor has to focus on performance problems. Again, regardless of whether disability played any part, okay? It's important also that the supervisor reiterate what the employee needs to do to improve performance. Okay, all right, so they've disclosed this disability, okay, but you still have to go through the process as if the disability has not been disclosed, regardless of what role the disability might have played, okay? Now, at this point, if the employee does not ask for an accommodation, the employer should ask whether, or may ask rather, whether there is an accommodation that might help raise the employee's performance level. Okay. So I just want to make one thing clear. Although the supervisor should not focus on the disability, the employer is permitted to ask under these circumstances whether there is an accommodation that might help raise the employee's performance. It's not, by doing that, it's not the same as really concentrating on the disability or asking questions, personal questions about the disability. So another scenario, which is very similar, is that now we're dealing with an employee who we know may have a disability, but right when we're going over their performance ratings or their performance evaluation, the employee suddenly asks for a reasonable accommodation. Okay, again, ideally, employees will request a reasonable accommodation before any performance problems arise. But the law does not require them to ask for an accommodation at a certain time. An employee is free to ask for a reasonable accommodation at any time. All right. So what happens? Well, the employer does not have to rescind any discipline that they were looking to impose, even if the discipline takes the form of a termination. Okay? So, for example, if the performance is so low or poor that the employer feels the employee should be terminated, you can go forward with that termination. You don't even need to address the reasonable accommodation request. Okay? However, if the performance is of the type that just requires reprimand or discipline, more so discipline, you don't have to rescind it, but you have to proceed and begin the interactive process to identify a reasonable accommodation. Okay? One of the things that I've seen over the years, and I've been, and a lot of times employers aren't even aware that they're doing this, but I've had to advise clients about this, is that you can't refuse to discuss their request for a reasonable accommodation, even if you're not so sure that it's a legitimate request. Okay? You shouldn't refuse to discuss it or fail to provide the reasonable accommodation as some form of punishment for the poor performance. For example, and this deals with a telecommuting arrangement. I've seen situations where if an employee's performance is poor, okay, or not up to a certain level, that an employee is not entitled to request telecommuting options, okay? However, when you're dealing with a reasonable accommodation, you certainly have to consider it if it's something that you do provide to your non-disabled employees. So that's very important that you go back and take a look at your policies with respect to that, just to make sure that they're not punitive, that the perks or that the terms and conditions of employment or withholding those terms and conditions of employment are not punitive to employees who require a reasonable accommodation. The reasonable accommodation needs to be determined and implemented as quickly as possible. You should not delay the process once an employee has asked for the reasonable accommodation, particularly when it's in response to a lower performance evaluation or rating. Okay? Where an employee fails to note the need for an accommodation until after a performance problem arises, reasonable accommodation, again, does not require you to tolerate or excuse the poor performance, to withhold discipline, including termination that's warranted by the poor performance. Again, not to raise the performance rating in light of the fact that, well, maybe the poor performance was attributable to the lack of a reasonable accommodation. And again, the lack of a reasonable accommodation that was never requested is really what I mean there. Or provide an evaluation that does not reflect the employee's performance. Now, one of the things that I've seen or I've experienced is that there tends to be sometimes with employees an accurate, to consider, there tends to be a fundamental misunderstanding for some employees sometimes that an employer is in fact required to tone down the evaluation once a disability has been disclosed or once a request for a reasonable accommodation has been made. Okay? And some employees seem to think that it's not permissible that the evaluation continue to be critical once there's been a disclosure. Okay? Please resist the temptation as a manager or supervisor to modify that evaluation. Again, the employee may misunderstand, but that's why it needs to be made clear to them that nothing, that the evaluation has to go forward because it is what it is. Okay, so please resist the temptation to sort of appease the employee by changing or modifying their performance rating. Another scenario that sometimes comes up is that the employee requests the removal of essential functions or the changing of performance standards as an accommodation. Again, the ADA does not require an employer to remove an essential function or modify performance standards. All you're required to do is modify or remove marginal functions, okay, or standards that aren't important or that are not dictated by the job or necessity. Of course, and employers do this all the time, you can temporarily remove an essential function or lower a quantitative standard if it's for a short defined period of time, due to a temporary medical issue. So, for example, recovering from surgery, recovering from a heart attack, based on due to for example, a pregnancy-related condition. You can impose temporary measures to remove an essential function for these things. You're not required to, but you can, and I do recommend that you do so, but not for a permanent disability. Okay, you should not be removing essential functions for in connection with a disability that's more important. Focus on accommodations that will enable an employee to perform satisfactorily and on the essential functions and their ability to meet the performance standards for the position. So now let's talk a little bit about conduct standards. When we talk about conduct, obviously we're talking about something different from performance or being able to perform the job. We're talking about behavior, okay? So right out of the gate, let me say that an employer obviously may discipline an employee with a disability for violating a conduct standard if the disability does not cause the misconduct. That's pretty clear, okay? Basically, if the disability has nothing to do with the misconduct, clearly you can discipline that employee. If an employee's disability results in the misconduct, okay, but the conduct standard itself is job-related and consistent with business necessity, okay, and other employees are held to the same standard, and I emphasize that other employees are held, non-disabled employees are held to the same standard, then the employee may be disciplined. So as long as the conduct standard is related to the job, okay, and it's necessary to the business, and you're imposing that conduct standard to non-disabled employees across the board, then you're permitted to go ahead and discipline the employee, even if the disability plays a role. Because the ADA, and neither the ADA nor state law protect employees from the consequences of violating conduct standards, okay, even where the conduct is caused by the disability. Again, as long as the conduct standard is legitimate, all right, you can disregard the disability in terms of imposing discipline. So when are conduct standards job-related and consistent with business necessity? Okay, so it's pretty clear that where conduct, standards that prohibit violence or threats of violence are certainly job-related and consistent with business necessity. So are prohibitions against stealing and destroying property, and yes, so are standards that prohibit insubordination. Okay. Clearly, when you're dealing with violence and you're dealing with stealing, those can also be crimes. Well, it doesn't have to rise. The conduct standard does not have to rise to the level of a crime. Insubordination is also a job-related and consistent with business necessity. Requiring respect for clients, customers, and the public. These are all job-related conduct standards. Also prohibiting inappropriate behavior between coworkers, and of course prohibiting alcohol and illegal drug use. or I should say the illegal use of drugs, because the drug itself doesn't have to be illegal. It could even be a misuse of prescription drugs that can certainly be prohibited in the workplace. Prohibiting alcohol in the workplace. These are conduct standards that you are entitled to impose because they are consistent with business necessity. The problem, though, arises with gray areas. Okay, like for example, some conduct standards are very ambiguous, like not prohibiting disruptive behavior. Well, what's disruptive? All right. Well, here are some factors to consider. All right. Consider the specific conduct at issue. Focus on the conduct and not what you think might be causing the conduct. Focus on the symptom of the disability that's affecting the conduct, as well as the nature of the work environment. All right, these are important factors, and I'm going to give you an example, and this is an actual real-life example that the EEOC has provided in its guidance. All right, so Darren is a longtime employee who performs his job well. Over the past few months, he's frequently observed talking to himself, though he doesn't speak loudly, he doesn't make threats or use inappropriate language, okay? However, some of his co-workers are uncomfortable around him. They complain to the division manager about his behavior. Darren's job does not involve customer contact or working in close proximity to other coworkers, and his conversations do not affect his job performance. The manager goes ahead tells Darren to stop talking to himself, but Darren explains that he talks to himself because of his psychiatric disability. He doesn't intend to upset anyone, but he can't control this behavior. And medical documentation that he provides supports this explanation. The manager doesn't believe that Darren poses a real threat to anyone, but he decides to, in order to appease Darren's coworkers, he transfers him to the night shift, where he'll be working in relative isolation and he'll have less opportunity for advancement. Basically, the supervisor justifies this by saying that he's doing it because the behavior is disruptive. So the question here is, was the manager's decision to transfer Darren consistent with the ADA's requirements, and really state law requirements? And I think the answer is no. Under these circumstances, it wasn't the conduct standard that this disruptive behavior was not job related and consistent with business necessity. Darren didn't need to be disciplined. Not only did he need to be disciplined, the discipline that was imposed would violate the ADA. You're transferring him to a night shift, where he's not going to have the same advancement opportunities, okay? Just really to appease coworkers. And really, it's the employee, it's really his coworkers who have the problem with his, it's their discomfort. While it's possible that, the symptoms of Darren's disability could, conceivably, in some instances, disrupt the ability of others to do their jobs, that's not the case here. Employees haven't complained that Darren is being too loud, that what he's saying is inappropriate, or that he's preventing them from doing their jobs. They just don't like being around someone who talks to himself. Okay, so their discomfort is never going to be sufficient to justify the discipline that Darren's manager imposed on him. Okay, here's another example in dealing with conduct standards. Again, this actually was a real case that happened in the Southwest of the U.S. So you have a telephone company employee's job. It requires her to spend 90% of the time on the telephone with coworkers working in remote locations, discussing equipment installations. Okay, the company has a code of conduct that requires workers to be respectful towards each other. Due to this employee's psychiatric disability, she tends to sometimes walk out of meetings. She hangs up on coworkers on occasion, and she uses derogatory nicknames for coworkers when talking with other employees. The employer warns the employee to stop her unacceptable conduct, but she continues, and so the employer issues a reprimand. Now, here we're talking about a situation where the employee's disability is really causing them to act out and to violate the code of conduct. So the question becomes, was the employer's decision to reprimand the employee consistent with the ADA's requirements? Okay? And the answer is yes. The employee's behavior violated a conduct rule that was job-related and consistent with business necessity. And therefore, the employer's actions are consistent with the ADA. The conduct standard was absolutely legitimate, and it was clearly job-related. You can't have employees being rude to each other, and you can require, obviously, that employees cooperate with one another. It doesn't matter that the employee's disability prevented them from communicating appropriately with coworkers. Now, what happens if this same employee requests a reasonable accommodation after being confronted with the reprimand? Okay? And, the answer is, in those situations, now that the employer has received a request for the reasonable accommodation, the employer should discuss with the employee whether there is an accommodation that would assist her in the future with complying with the code of conduct. Okay? That doesn't mean that we're taking away the reprimand or we're excusing the employee's performance. The employee is still going to be reprimanded, okay? But we need to address the accommodation and to see if there's a way to prevent this in the future so that the employee can continue working for the telephone company, okay? Again, withholding disciplinary action or changing a conduct rule as an accommodation is not required by the ADA, but the focus needs to be on an accommodation that will enable the employee to meet the conduct standard, okay? So if you don't remember anything from today, this is what you certainly should remember. The timing of a reasonable accommodation request and what your options are as an employer, okay? If the performance issue or the misconduct warrants termination, you can go straight to termination, okay? Even if a reasonable accommodation request is made after the performance issue and the misconduct that warrants termination, you don't have to address the reasonable accommodation. You can proceed with the termination. What if the request for an accommodation occurs after the performance issue or misconduct that warrants discipline other than immediate termination? Well, you're certainly allowed to impose discipline, but you need to begin the interactive process, okay? Now, there's an exception to all of this, where the employee's poor performance conduct is due to the current illegal use of drugs. That employee is not entitled to a reasonable accommodation. You're not barred from accommodating them in some way, but you are certainly not required to, because current illegal, and I'm emphasizing the word current illegal users of drugs are not protected by the ADA. Alcoholics, on the other hand, current alcoholics are certainly protected by the ADA and could be entitled to a reasonable accommodation. Again, it's important to handle these requests expeditiously, because once a request is made, the failure to act could prevent a correction of the problem, and further discipline could be met with a claim or an assertion that the employer was aware of the disability, the employer was aware of the need for a reasonable accommodation, but otherwise failed to act. Always focus on what the employee is doing wrong. Be specific, okay? Be specific. Be specific in what you expect the employee to do to improve, and be clear about the consequences if there's no improvement. You should not raise a disability, the concept of disability out of the gate, okay? But only respond if the employee first raises the disability, because an employer raising it could lead to a claim that the employee is being regarded as disabled, okay? And remember, the definition of disability includes not only an actual disability, but being regarded as having an impairment that could be a disability, okay? And that's a problem too, which is why it's generally not appropriate for an employer to raise the possibility of a disability, okay? Because and keep in mind that you might ultimately have to defend your discipline to the EEOC at some point in the future. Okay. Now, finally, I do want to make a point about potentially violent conduct, and this sort of goes back to some extent to the example I gave about Darren earlier. Okay. Distinguish between real threats and behavior that is simply just outside the norm. Making threats is misconduct, and making threats can be punished regardless of whether the threats are attributable to a psychiatric disability, okay? But don't assume that an employee with a particular mental illness will become violent, because that's where we get into the area of illegal stereotyping. And all discrimination law, including disability discrimination, really exists to prevent illegal stereotyping. If behavior is causing a problem, deal with it as strictly as a personnel issue, and not as you would a real threat sort of issue. Okay, and that's basically it. So if we've come to the end of our program, and I hope you found it helpful. Again, all of today's participants will be receiving an email with the PowerPoint slides, a link to the webinar recording, and an attendance certificate. So be on the lookout for that. If you have any questions, and I don't believe we have any current questions listed right now. Yeah, I don't see. Let's see, maybe I'm wrong. Nope, we don't have any questions. Okay, well, look, if any questions come up in the future, please feel free to contact me, Sal Gangemi. I can be reached at 203-653-5436. Again, I thank you for joining us, and we hope you join us for our next webinar entitled #MeToo, How Cultural Chance Has Impacted Interpersonal Boundaries in the Workplace, and that's scheduled for May 23rd. Thanks very much, and have a great weekend.